I have watched emergency rulings reshape law before, not through the careful deliberation of months-long litigation, not through oral arguments broadcast to the public, through unsigned orders issued late on Friday afternoons that changed the legal landscape before most people realize what happened. And the confusion that follows is not accidental, it is structural. Because emergency rulings operate in the gap between what the court actually decided and what people believe it decided. In late January 2026, the Supreme Court issued an emergency order in a case that most media outlets described as ending concealed carry permit requirements nationwide. The headlines declared that permits were no longer necessary. Social media filled with claims that anyone could now carry a concealed firearm anywhere in America without government permission. Gun rights organizations celebrated. Gun control advocates warned of imminent chaos. And within 72 hours, the actual text of the order had been buried beneath layers of interpretation, speculation, and misinformation that bore little resemblance to what the court had actually done. The case at the center of the emergency order was Alvarez versus Hawaii. The plaintiff, a Hawaii resident, had applied for a concealed carry permit under the state's licensing system. Hawaii operates what legal scholars call a may-issue regime. The state requires applicants to demonstrate good cause for needing a permit, and licensing officials have discretion to grant or deny applications based on their assessment of whether the applicant has shown sufficient reason to carry a concealed firearm. This is the same framework that existed in New York before Bruin struck it down in 2022. After Bruin, Hawaii did not immediately change its law. The state argued that its good cause requirement was different from New York's proper cause requirement and therefore survived Bruin's reasoning. Alvarez applied for a permit, was denied for failure to demonstrate good cause, and filed suit arguing that Hawaii's system violated the Second Amendment under the standard established in Bruin. A district court agreed and issued a preliminary injunction ordering Hawaii to issue Alvarez a permit. Hawaii appealed to the Ninth Circuit, which stayed the district court's injunction, allowing Hawaii to continue denying the permit while the appeal proceeded. Alvarez filed an emergency application with the Supreme Court, asking it to vacate the Ninth Circuit's stay and reinstate the district court's order requiring Hawaii to issue him a permit. The Supreme Court granted that application in a brief, unsigned order. The order stated that the Ninth Circuit's stay was vacated and that the district court's preliminary injunction requiring Hawaii to issue Alvarez a permit was reinstated, pending further proceedings in the lower courts. That is what the order actually said. It did not strike down Hawaii's permit system. It did not declare that permits are unconstitutional nationwide. It did not eliminate licensing requirements in any state other than Hawaii. It ordered Hawaii to issue one specific person a permit while his lawsuit continues through the courts. The order applied only to Alvarez. It applied only to Hawaii. And it was an emergency procedural ruling about whether a stay should remain in effect, not a final decision on the merits of Hawaii's permit system. But the way emergency orders function creates confusion by design. The court issues them quickly, often with minimal explanation. There are no oral arguments. There is no lengthy majority opinion walking through the reasoning. Just a brief order stating what the court is doing in this specific case. And because the order is procedural rather than substantive, it does not create binding precedent that governs other cases. Lower courts in other jurisdictions are not required to follow it. It resolves the immediate dispute and nothing more. Yet the practical effect of even a narrow emergency order can be substantial. By vacating the Ninth Circuit's stay, the Supreme Court signaled that it views Hawaii's may-issue system as likely unconstitutional under Bruin. That signal matters, even though the order is not binding precedent. District courts in Hawaii now know that if they issue injunctions against the state's permit system, the Supreme Court will likely uphold those injunctions on emergency appeal. That makes litigation against Hawaii's system more likely to succeed, which in turn pressures Hawaii to change its law rather than continue defending it through years of litigation it will probably lose. Hawaii is not the only state operating a may-issue system after Bruin. California, Maryland, Massachusetts, New Jersey, and the District of Columbia all maintain discretionary licensing frameworks. But each of those jurisdictions modified their laws after Bruin to remove or narrow the discretionary criteria that the court found unconstitutional. California replaced its good cause requirement with a requirement to demonstrate good moral character. New Jersey did the same. Maryland and Massachusetts adopted similar approaches. The District of Columbia shifted to a shall-issue system where any applicant meeting objective criteria receives a permit automatically. Hawaii was the outlier. It kept its good cause requirement and argued that Bruin did not apply. The Supreme Court's emergency order in Alvarez strongly suggests that argument will fail when the case reaches final judgment. But that final judgment has not been issued. The case is still in district court. Hawaii could settle, moot the case, or change its law to avoid an adverse ruling. Until a final judgment is entered, Hawaii's permit system remains formally in effect for everyone except Alvarez. The distinction between may-issue and shall-issue systems is critical to understanding what the emergency order does and does not accomplish. In a may-issue system, applicants must convince licensing officials that they have a good reason to carry a concealed firearm. The officials have discretion to grant or deny based on their judgment about whether the applicant's reason is sufficient. This creates a system where identical applicants can receive different outcomes, depending on which official reviews their application and what standards that official applies. In a shall-issue system, the law specifies objective criteria such as completing a training course, passing a background check, being a certain age, and having no disqualifying criminal history. If an applicant meets all the criteria, the state must issue the permit. There is no discretion. The system operates mechanically based on whether the applicant checks the required boxes. Bruin held that may-issue systems violate the Second Amendment because they give government officials discretionary power to decide who deserves to exercise a constitutional right. Shall-issue systems survived Bruin because they impose objective requirements without discretionary approval. The Supreme Court did not hold that all permit requirements are unconstitutional. It held that discretionary permit requirements are unconstitutional. This means that states can still require permits for concealed carry as long as the requirements are objective and non-discretionary. Training requirements, background checks, fees, age minimums, and residency requirements all remain constitutionally permissible under Bruin. What states cannot do is require applicants to prove they have a special need that justifies exercising their Second Amendment rights. 27 states currently have constitutional carry laws that eliminate permit requirements entirely. In these states, any person who is legally allowed to possess a firearm can carry it concealed in public without obtaining government permission. But 23 states still require permits. Most of those states operate shall-issue systems that Bruin explicitly allows. The Supreme Court's emergency order in Alvarez does not affect those states at all. The confusion stems from the gap between the technical legal question the court resolved and the broader political narrative surrounding gun rights. Gun rights advocates have been pushing for recognition that the Second Amendment protects a right to carry firearms in public without needing to justify that decision to government officials. The Alvarez order advances that goal by signaling that Hawaii's discretionary system is unconstitutional. But it does not eliminate permit systems generally, and it does not establish that any American can carry concealed anywhere without restriction. What the order does is accelerate the legal pressure on the remaining may-issue jurisdictions. If Hawaii eventually loses this case and is forced to adopt a shall-issue system or eliminate permits entirely, California, Maryland, Massachusetts, New Jersey, and the District of Columbia will face renewed challenges arguing that their modified systems still contain too much discretion. Those challenges will cite the Supreme Court's willingness to intervene on emergency appeals as evidence that the court views any discretionary element in permit systems as constitutionally suspect. But those challenges have not been filed yet. The cases are still hypothetical. Until they are litigated and resolved, the current permit systems in those jurisdictions remain in effect. Gun owners in California still need permits. Gun owners in New Jersey still need permits. The emergency order in Alvarez does not change their legal obligations. The practical impact on the ground in Hawaii is also more limited than the headlines suggest. The district court's preliminary injunction orders Hawaii to issue Alvarez a permit. It does not order Hawaii to issue permits to everyone. Other Hawaii residents who want permits still need to apply, and if their applications are denied, they still need to file their own lawsuits. The Alvarez case might create favorable precedent that makes those lawsuits easier to win, but it does not automatically grant permits to anyone except Alvarez. Hawaii could respond to the emergency order in several ways. It could change its law to adopt a shall-issue system, eliminating the good cause requirement that the Supreme Court clearly views as unconstitutional. This would moot ongoing litigation and allow the state to maintain a permit system with objective requirements. California, New Jersey, and other states took this approach after Bruin, rather than continuing to defend discretionary systems through years of litigation. Alternatively, Hawaii could eliminate permits entirely and adopt constitutional carry. Several states that previously required permits shifted to permitless carry after Bruin on the theory that if discretionary requirements are unconstitutional, the simplest solution is to eliminate requirements altogether rather than constructing an objective system that might face future legal challenges. This approach has political appeal for gun rights advocates, but faces resistance in states where public opinion favors permit requirements. Hawaii could also continue defending its current system through final judgment in the Alvarez case. This strategy delays any change while the case proceeds through district court, potentially the Ninth Circuit again, and possibly back to the Supreme Court for a final decision. That process could take 2 to 3 years. During that time, Hawaii's permit system would remain in effect for everyone except plaintiffs who successfully obtained preliminary injunctions in their own cases. This approach makes sense only if Hawaii believes it has a strong legal argument that distinguishes its system from New York's, or if the state wants to exhaust all legal options before making policy changes. The emergency order also has implications for the sensitive places restrictions that several states enacted after Bruin. New York, California, New Jersey, and Hawaii all responded to Bruin by dramatically expanding the list of locations where concealed carry is prohibited, even for permit holders. These sensitive places laws have faced their own legal challenges, and some have been preliminarily enjoined by district courts. The Supreme Court's willingness to intervene quickly in Alvarez suggests it may also be willing to grant emergency relief in sensitive places cases, if plaintiffs can demonstrate that lower court stays are preventing them from exercising Second Amendment rights while litigation proceeds. But again, the court has not ruled on the merits of sensitive places laws. The emergency order in Alvarez concerned only permit systems. How the court will evaluate location-based restrictions remains an open question that will be answered through future cases, not through emergency orders about Hawaii's licensing framework. What makes emergency rulings particularly consequential is their speed and their lack of transparency. Normal Supreme Court decisions take months, briefs are filed, oral arguments occur, justices deliberate. A written opinion explains the reasoning. Emergency rulings bypass all of that. They resolve immediate disputes without establishing clear rules for future cases. And because they are issued quickly and with minimal explanation, they create ambiguity that lawyers, lower courts, and the public must interpret without clear guidance. That ambiguity is not a bug, it is a feature. Emergency rulings allow the court to intervene in urgent situations without committing to the broader implications of its decision. The court can signal how it is likely to rule when a case reaches final judgment without actually issuing that final judgment prematurely. And if the parties settle or change their behavior in response to the emergency ruling, the court avoids having to address difficult constitutional questions at all. The Alvarez order fits that pattern perfectly. The court did not strike down Hawaii's permit system. It did not issue a sweeping ruling about the constitutionality of licensing requirements. It simply said that while this case proceeds, Hawaii must issue one person a permit. That narrow intervention signals the court's view without committing to a final outcome. And the signal is strong enough that Hawaii will likely change its law. Rather than continuing to defend a system, the court has indicated it views skeptically. I have watched this dynamic before. Not the sudden transformation of law through comprehensive rulings, but the incremental adjustment of legal frameworks through procedural orders that most people do not read or understand. The headlines declare victory or defeat. The reality is more subtle. The law changes slowly, through accumulated pressure, through strategic litigation, through the quiet capitulation of jurisdictions that recognize they cannot win. Hawaii's permit system is probably doomed, but it has not been struck down. Concealed carry permits have not been eliminated nationwide, and the Second Amendment framework established in Heller and refined in Bruin remains intact. States can regulate firearms through objective, non-discretionary requirements rooted in historical tradition. What they cannot do is give officials the power to decide who deserves constitutional rights based on discretionary assessments of need. The emergency order in Alvarez clarifies nothing and changes everything. It resolves one procedural question about one stay in one case, and in doing so, it accelerates the end of discretionary permit systems nationwide. Not through a single ruling, but through the cumulative weight of pressure that emergency intervention creates. The law has not changed, the trajectory has. And trajectories, once established, are difficult to reverse.